Good evening, everyone, and welcome to the online discussion of Judge Sporkin Career and Legacy, organized by the Washington Foreign Law Society. I'm Juliana Canet, the president of the Washington Foreign Law Society, founded in 1952 to promote knowledge and understanding of international legal matters, comparative legal issues, and foreign law. This evening, we host a very distinguished panel of Washington attorneys who participated in key phases of the impactful career of Judge Sporkin. We are pleased to have many registered participants, including members of Judge Sporkin family. Given the high number of participants, you will be muted during the webinar, but you will be able to communicate with us via Q&A section or chat. Please send questions for the panel using the Q&A section on your screen, and we will get to your question toward the end of the presentation. This session will be recorded. I give now the floor to Mr. Feldman, the moderator of our panel. Welcome.
Thank you, Juliana. I want to now. I'm still looking at your screen. Now that's changing. Okay. First of all, I want to thank the Washington Foreign Law Society for sponsoring this program. The officers and colleagues at the Society recognized immediately that Judge Stanley Sporkin was a unique personality. He had a fabulous career, and he was a marvelous human being, although he was controversial at times, because when you're trying to do great things, or the right thing, sometimes, and you're determined to do it, you can rub people the wrong way. Anyway, we're very happy to have with us three distinguished attorneys who work with Judge Sporkin at different phases of his career. And this is going to be a kind of, the first part of this program is going to be kind of a chronological survey of the individual's experiences with Judge Sporkin and his impact on the various areas of law, beginning with the Securities and Exchange Commission, and then the Central Intelligence Agency, and then, of course, his very significant judicial legacy. All three of these gentlemen are distinguished attorneys. I'll mention very briefly the highlights of their positions, but what's really important tonight is their very special, each of them has a very special relationship had a very special relationship both with professional and personal with Judge Sporkin. I wish I had that lifelong relationship, but I did have the opportunity to work closely with him when I was at the State Department, and he was pursuing perpetrators of foreign bribery, domestic and foreign, and you can imagine, we'll discuss a little bit later some of the foreign relations implications of that. So our first, just to introduce briefly each of the speakers, and they will say more about their connections with Judge Sporkin as we proceed. Before going to that, I would just like to welcome all the members of the Sporkin family who are here and give them everyone's condolences and everyone's pride and affection in Judge Sporkin. Our first speaker of the evening will be Eugene Goldman, and Gene is now a senior counsel at McDermott, Will and Emery, but he was a practicing partner there for 25 years, and he's still very active in the white collar crime and securities law areas. Gene also has played a major role in putting this panel together and bringing Ted Olson and Jim Zirkle on board, and I'm very grateful for that as well. But the most important thing I have to say about Gene is that he was working at the SEC with Judge Sporkin when he initiated these explosive investigations back in '75 and '76. And years later, he became Judge Sporkin's first law clerk That's quite a connection. Jim Zirkle has had two careers, one in academics and one at the CIA, and he did supremely well in both of those. I guess, Jim, you reached out to Judge Sporkin when you were at Yale, and he was a valuable asset in your course, and then he recruited you to the CIA, and you had a long career working with Sporkin at the CIA, and you're going to tell us something about that. And right now, as I understand it, you're teaching at Georgetown, as I am, and also at American University. Now, Ted Olson needs no introduction to this audience. He is a partner, of course, at Gibson, Dunn & Crutcher, but we all know him as a public figure, having been Assistant Attorney General for the Office of Legal Counsel and then Solicitor General. What I had not appreciated until I saw his bio was that he's had 65 Supreme Court arguments. And he was telling us, the panelists, some of his experiences with Judge Sporkin, which began when the judge was General Counsel of the CIA, and Ted was over at the Justice Department as an Assistant Attorney General. Before beginning, turning the panel over to the speakers, it's my understanding that there may be a few out among our participants, now up to 122, who are not senior citizens and who therefore, unlike yours truly, may not remember the events of 1975 and 1966 that brought Judge Sporkin to national, and I would say in a dramatic fashion, to international attention. And that is when he began initiating the investigations of foreign bribery by U.S. corporations. And of course, a particular responsibility was compliance with the security laws. But it went well beyond that. It's very hard to convey in these critical times that we're going through now, what a tremendous impact those investigations had on public life in the United States and abroad. Every time there was a major investigation or disclosure of that one of America's major corporations was accused of or admitted to bribery of foreign officials, that generated congressional hearings. There were 4 or 5 separate congressional hearings on particular cases, one involving Gulf Oil, Northrop, Mobil Oil, Lockheed, and these hearings and the disclosures of the agency generated a media frenzy, and not to mention the impact that it had on the corporate boards of the United States. And I can tell you that it had a tremendous impact on U.S. foreign relations. Governments were challenged, politicians were arrested, friends of the United States were in deep trouble, including members of the royal family in the Netherlands. So this was, and I just to mention 2 other points before giving the panel a chance to elaborate on all of this. Between June 1975 and September 1977, approximately 20 bills were introduced in Congress to address the foreign corporate payments problem. In addition to that, the United Nations created an entire new committee with practically all the members of the UN participating in that committee to deal with the consequences or with the problem of foreign bribery that was exposed by Judge Sporkin's investigations. And I'll close this introduction by just quoting Judge Sporkin himself in a law review article that he published in 1997 on the 20th anniversary of the Foreign Corrupt Practices Act. And that article has a wonderful title entitled Schmiergeld, And to quote Judge Sporkin, in my 40 years as a practicing attorney, there is no accomplishment of which I am more proud than the contribution I made by assisting in the creation of the Foreign Corrupt Practices Act. Well, we were sometimes on the other side of the issues, but I came away with enormous respect and great affection for Judge Sporkin. So I'd like to ask Gene Goldman to take it from there and fill in the details, which are pretty important.
Thanks very much. I am very honored to be included in this tribute to a once-in-a-generation true patriot to his country. And I know the Sporkin family is grateful for the outpouring of support with former commissioners, general counsel, division directors, his law clerks, many others joining us today. While Stan's incredible career and legacy are the focus for today, such a discussion would be incomplete without first remembering his true friendship. Someone willing to help so many with their careers. Someone who stayed in our lives well beyond the time we worked with or against him. Officiating at our weddings, being the best man, making that phone call or letter recommendation, being there for Bill, Dick, Steve, Linda, and support. Okay. Have you been able to hear me so far?
There was a brief beep. We're back.
Okay. Did you hear what I've said so far?
Yes.
Okay, good. He learned being a mentor from having a great one of his own, his beloved predecessor and SEC Commissioner Herb Pollack. Stan showed his generosity by picking up the tab every year at the annual dinners with his former clerks and their families. Most importantly, he taught us what is right and just. We all got a sense while working under Stan in the division that no matter how important or powerful the person or firm was under investigation, whether it was President Carter's friend and OMB Director Burt Lance, George Steinbrenner, William F. Buckley, Charles Bluedorn and Gulf and Western, Mashum Rickless, if there was alleged wrongdoing, they would be held to account, but in a fair way. And the investing public will learn the charges. This says much about Stan's reputation for toughness and fairness that the most aggressive pillars of the corporate defense bar and public advocates such as Ralph Nader praised Stanley at the same time. The enactment of the FCPA flowing from the division's foreign payments program is a huge part of Stan's legacy. Monetary recoveries in FCPA cases last year topped $2.5 billion for the first time in the 50-year history of the statute. But to do justice to Stan's achievements, let's briefly highlight some successes policing the markets and promoting corporate integrity, all to the benefit of our capital markets. As Joe Seligman wrote in his brilliant treatise on the history of the SEC, no history of the SEC would be complete without noting the competence and ingenuity of Stanley Sporkin. And to put this in context, I'd like us all to remember that Stan operated years before Congress enacted legislation that beefed up enforcement powers through the Remedies Act and Sarbanes-Oxley, which specifically provides for the court's exercise of power to grant equitable relief. He believed that the Exchange Act's express power of an injunction against violative conduct was insufficient to deter wrongdoing. In response to the division's enforcement actions, courts uniformly agreed to exercise the court's general equity powers to impose ancillary remedies and afford additional relief. Exhibit A was court-ordered disgorgement of the ill-gotten gains of the securities violator. The use of consent decrees, which Ted Levine and Ed Early have described in their article, The Father of Enforcement, as Stan's greatest achievement, in leading the Commission's expanding enforcement program. The size of the enforcement staff did not keep up with the ability to fully investigate and litigate each matter. So the consent decree program helped Stan gain the biggest bang for the buck. Consent decrees were agreed to by the defendants, by which they agreed to injunctive and other relief without admitting or denying the allegations brought by the Commission. This afforded the defense protection against adjudicated findings of fraud that could be used against them in res judicata in criminal and civil proceedings. At the same time, defendants invariably consented to appoint special counsels to recover assets. In the Vesho case, some of you may remember, the special counsel seized a yacht, a Boeing 707, and 800,000 shares of ICC stock that Vesco had transferred to his family. Defendants also consented to investigate and report on further wrongdoing and ratchet up compliance programs, like in the Rickless Rapid American case, where after a 2-year probe, the company consented to adding 4 new directors to a transaction review committee to look out for conflicts of interest in future dealings involving Mr. Rickless. The last item I like to discuss before I discuss the FCPA is Stan's creativity in pursuing gatekeepers, the centuries of the marketplace, the accountants, attorneys, research analysts, and the boards of directors. Not only as subjects of enforcement proceedings, but to send a message that they needed to do a better job of self-policing the firms they serve. He dusted off Rule 2E to bring administrative proceedings publicly against accountants, including CFOs holding CPA licenses and attorneys who help prepare false disclosure documents. Again, to stretch every dollar in the battle to check abuse in the markets, Stan focused on pursuing wrongdoers and those asleep at the switch who provided access to the securities offerings in the markets. Steve Cutler, division director following the scandals that led to the enactment of Sarbanes-Oxley, publicly credited Stan on the work the division was building from in this area. I noted that Stan referred to this approach as the access theory. The deterrent effect led to widespread self-policing in the appointment and designation of chief compliance officials and compliance departments. Now with respect to this FCPA. Mark recalled that the State Department opposed Stanley's efforts to pursue companies for foreign bribery. Stan disagreed with the State Department's position. He believed that the bribery of foreign officials damages investor confidence in our corporate institutions, that it made no sense to have the purchase of goods and services depend on whether a particular general or minister was in place to accept bribes. He believed that it was a material undisclosed risk to shareholders that big orders, construction contracts, military sales depended on bribery. His concerns were compounded when he learned that unaccounted for cash, slush funds, phony contracts, and disguised transactions were falsely recorded on the books and records of public companies. It is well known that Stan knew something was amiss from watching the televised hearings involving Watergate and the revelations of publicly traded corporations made off-book secret contributions to the campaign to re-elect President Nixon. The SEC was granted access to the records of the Watergate Special Counsel, and Stan was off to the races. He had the division commence investigations, and the results transformed America. This led to numerous injunctive actions and court-approved consent decrees, mandating the use of special boards, committees to oversee internal investigations and the adoptions of compliance controls. But the great number of companies suspected of making illicit payments was too large to investigate on a case-by-case basis without blowing a huge hole in the SEC's budget. Remember, there were a lot of other things to do, plenty of other things to do, involving insider trading, market manipulation, undisclosed related party transactions. So what followed, as Mark alluded to, was a voluntary disclosure program, which allowed a firm to avoid an SEC enforcement action by conducting its own investigation of the payments, supervised by the company's non-employee directors, often with the use of independent counsel. The results of these investigations became public. 400 firms voluntarily admitted to having bribed foreign or American or commercial officials who were making illegal campaign contributions. Congress decided to weigh in, led by Senator Proxmire, chairman of the Senate Banking Committee, whose staff requested Stan's help in drafting legislation to address the widespread abuse. Now, Stan and the chief accountant at the time of the SEC, Sandy Burton, drafted what became known as the accounting provisions of the FCPA, prohibiting false books and records and mandating a system of accounting controls to accurately record transactions. This was not enough for Senator Proxmire, who inserted an anti-bribery provision into the FCPA. The rest is history, and with robust enforcement by the SEC and the DOJ in the last several decades, along with their international counterparts through unilateral and bilateral assistance agreements, scores and scores of actions have been filed. As I mentioned, huge sums have been collected by way of fines and disgorgement. Violations of the FCPA accounting provisions, which do not require the intent to defraud, live on in numerous false financial cases that have nothing to do with bribery. And in many FCPA cases, the accounting provisions are used when it's hard for the government to prove the bribe, much easier to prove the sham consulting contracts and falsely recorded transactions. Senator Proxmire had great confidence in Stanley. It was a real spectacle to see at confirmation hearings that Senator Proxmire would elicit pledges from future SEC commissioners that they would take no steps to remove Stan from his position, something that is unheard of today. I have more, but perhaps I can fill that in later.
Yes, thank you very much, Gene. We will have plenty of opportunity after the other speakers, panelists have had a chance to broaden the conversation to discuss foreign bribery then and now. I just, if you forgive me, I have to make one observation on what you said about the State Department. I can't speak for Henry Kissinger or senior officials, but in my day-to-day work with foreign companies, with foreign official governments that were affected, with US companies that beat their way to the doors of the State Department, the Hill, the interagency, I don't recall the State Department ever opposing any action by the SEC. My role certainly was in representing the State Department in the interagency. The department and other agencies in the national security community opposed national legislation which would institutionalize US government surveillance of foreign officials. So in the early years, that is to say the 4 years, we did resist the recommendations of the task force, which was organized by, led by Elliot Richardson. But ultimately, the Foreign Administration, somewhat grudgingly, came to support a disclosure bill. In the fullness of time, Jimmy Carter campaigned for the election of 1976 on the theory of criminalization. And of course, state was very unhappy with that, but we had no, the boss put that on the table and that was it. So we can discuss the merits of it. If you look at my testimony, several times I testified on the FCPA at the future, what was not yet the FCPA, on these legislative proposals in the Ford years, and you'll see we were always concerned about the extraterritorial implications. But we can all come back to that. There's so much more to say about it. I want to give Jim Zirkle a chance. Moving on to Judge Sporkin's elevation to the general counsel position in the CIA. And I have to say that I know there were a lot of people, including some in the State Department, who were unhappy with the vigor with which he enforced laws affecting our foreign relations. And I know from a very early, I can remember people more senior than myself saying, let's get Sporkin out of the SEC. And I guess it did happen in the Reagan administration. He moved on to the CIA, but that also was a fabulous or very successful chapter. So tell us about that, Jim.
Well, when I was in New Haven, Stan would come up. He was at the SEC, and he was very popular with the students, of course, because he was wearing the white hat. And he could draw a crowd of students that probably would have been equaled only by one of the Supreme Court justices in the big classroom. And I would try to, usually I would have breakfast with him or lunch with him while he was there. And I remember this must have been around 1980 or 81. He mentioned that that Casey was bringing him over to the CIA as general counsel. And I remember saying to him then that that sounds like a very interesting assignment. Little did I know that, a couple of years later, I would be down there working for him at the CIA. It's an honor to be here participating in this tribute. It's an honor to be associated with these distinguished panelists, I should say. I was privileged to know Stan for over 4 decades, actually, and when he went on the bench and then later into private practice, he was quite a chess player, and we would occasionally get together for lunch after he retired more often. His assistant, Dee Burrell, would always have things set up for us down in his office suite, and we would play chess. I have to report he won about 75% of those. He was a killer of a chess player. But while we were playing chess, he would also talk about what was going on in the securities area or the international law area. He had a very inquiring intellect, and he was always interested in the public policy and in the ethics of what was going on. At the CIA, he had an open door policy. The office in was very much smaller than it is now, and particularly he was interested in the newer attorneys that came in, and he had an open door. They could come in and talk to him, and he would I teach them, I think, about law and ethics. These were mostly people just out of law school, not all of them. I know that we had the younger women that came in would remind him on a regular basis that he had no women in supervisory positions, and I think he started the movement of putting women in senior positions at the CIA General Counsel's office. I remember being called into his office at one point about something else, and he said, "What did you think about that case today?" And I said, "What case?" And he said, "Well, the Supreme Court just came down with this securities case." Well, I am not now, nor have I ever been a securities lawyer, but I learned from that I had to get the office librarian to copy out for me every case that she gave to Stan so that I would at least be able to say I'd read the case. He would gather up the newer attorneys for lunch. He liked to eat at this seafood place, now out of business. And we would have some pretty vigorous discussions along with Bob LaPrade, who came over with him from the SEC, who was, I guess, a senior litigator over there. Anyway, it was quite an informal and a very instructive period for all of us. And I certainly learned a great deal from Stan, both then and later on. I would just say, as a reminder to everybody, I want to give you a couple of examples of what he did at the CIA in terms of both following the law and following public policy. But I would remind those that might not have looked at the CIA lately, it is, of course, a federal agency. It's authorized, it was created by Congress. Its authorities come from Congress. Its funding comes from Congress. And it has to follow federal law. And Stan was very careful to make sure that that was the case in anything that he was involved in. But I want to give you two examples. I don't know everything he did at the CIA. It's compartmented out there, but I have two examples that I can just share with you. One was on the public interest side. General William Westmoreland filed a lawsuit against CBS News, alleging that they had libeled him in a production that they did on Vietnam, and they alleged that he had lied to the public about such things as the enemy's order of battle and the size of the opposition there and so forth. And in the course of that, in the early discovery period, they wanted access to CIA records because there was a difference between the between the manning of the North Vietnamese forces. The Army looked at organized units of the Army of North Vietnam, whereas the CIA looked at that plus the Viet Cong. And Stan gave advice to the agency. He said, look, first of all, the agency has no dog in this fight, and we don't want to be in a position of trying to litigate the Vietnam War 10 plus years after it's over. And second, there's a public interest part of this, because the public has a right to know if the government, and if Westmoreland in particular, was lying to them. So Stan arranged to have the documents that they wanted released to them. And it became apparent, looking at the order of battle, that Westmoreland had just been working from a different set of data in that particular regard. In fact, he sent Bob LaPrade and me down to observe some of the proceedings. And in one of the, we sat in on one of the, I guess it was some kind of hearing before one of the federal judges. And they had this really excellent litigator who was representing Westmoreland. He was represented by a very small public interest law firm. CBS News was represented, I think, by Cravath. Anyway, one of the big New York law firms. And she did such a great job that Stan, when this was all over, hired her. The suit eventually went away because the little law firm got out litigated by Cravath, or whichever firm it was. Anyway, that was an example where Stan was looking at the larger picture, as he always did, in terms of what is in the interest of the public here and what is in the interest of the CIA, his client. The other example I would use is one you're going to be very familiar with, and that was Iran-Contra. And I was not involved in that myself. Stan told me some of the things that happened in there. He told me that he mentioned that one day I guess the deputy director at that time, John McMahon, Casey was somewhere else. McMahon found out that the CIA had been involved in some arms transfers to Iran, and sent some senior directorate people over from the operations side to brief Stan. He told them, you can't do this. Can you hear me, Mark? Am I getting through? Okay.
You're back.
I'm back. I don't know. Well, maybe you missed some of what I said, but it's probably no loss anyway. So, but in terms of Iran, exchange of weapons for hostages held in Lebanon, Stan said, you've got to have a finding. And Stan and the agency said to the White House, for us to have any participation in this, we have to have a presidential finding, which was the law. Stan told me the White House didn't want to do that, but they eventually did. And the finding is more than just saying, I'm authorizing the CIA to do X, Y, and Z. It has to set forth a finding by the president that the activities that are being authorized are in the interest of the foreign affairs or national security of the United States. And so Stan insisted that finding not only authorize ongoing operations, but it did two other things. It ratified the activities that had taken place before the finding. I'll come back to that in a moment. And it also required that the finding, in saying what the purpose of these transfers were, would very clearly state that this was an effort to exchange weapons for hostages with the Iranians. Now that went against the Reagan administration's public policy of, we do not deal with terrorists. We don't exchange weapons for hostages or anything else. And it also went against what the United States and Mark can speak to this better than I can, but the United States have been urging its allies not to provide weapons or other incentives to the Iranians to release the hostages, if that was a bad policy. So Stan, as a corporate lawyer, thought, well, if we had a CEO of a corporation that discovered that the corporation had been doing things without the necessary board of directors authority, what would they do? You would go to the board of directors and say, this is what we've done, and we would like to have you ratify what has already been done. And that's what Stan did with this finding. That came to be characterized as a retroactive finding, but it wasn't, and it was retroactive in terms of the authorization of what had happened before, but it was not something like backdated or anything like that. So Stan, I think not long after that, went on to the bench. I think the finding was issued in January, I think, of 85 or 86, January of 86. The other question involved in that was, well, what about notifying Congress? Two reasons to notify Congress. One, the CIA is involved now in a covert action. And second, these arms transfers under the Arms Export Control Act, at least some of them were supposed to be pursuant to notification to the Congress. The Congress was notified about 10 months after that finding was signed. We can come back to the Arms Export Control Act if you like, but I think that Stan had the total blessings of Director Casey, so that gave him a enormous sway in the Central Intelligence Agency with everybody. And sometimes when someone would say, well, what you're saying here is really not a legal issue, it's really a policy issue, Stan was very fond of saying, look, I'm the general counsel and I will give general counsel. So a lot of people learned from him. The office was started to build up under him. And he was very beloved, I guess, by particularly the younger attorneys, but also the more senior attorneys that had been there for a while. I can stop there because I know I'll get questions about this. Maybe someone will talk about the Arms Export Control Act. I don't pretend to be an expert on that. But what I would just say in terms of the notification there, maybe then this will forestall the questions. That statute also provides that notifications to Congress can be done pursuant to the provisions in the National Security Act of 1947 for reporting covert actions. And so what was done in this case, the notifications to Congress, so far as I'm aware, and I think this is correct, were done pursuant to the covert action notifications rather than the Arms Export Control Act directly. I'll stop with that, Mark, and
well, thank you very much.
Relinquish the remaining time back to you.
Well, thank you, Jim, and I applaud your the bravery which you stepped into beyond management and friendship to matters as controversial as the Iran-Contra. I'm sure we'll get back to that. Let's turn the floor over now to Ted Olson. Well, we had a little bit of a preview a few days ago in a rehearsal of what he's going to say, and it's going to be of great interest to all of you.
Well, thank you very much, Mark, and to the Sporkin family and to all of you for including me in this program. It's an honor to be a part of it, and it's an honor to talk about Stan Sporkin. In part because it's great to talk about him, but it was also great to think about my memories and my experiences with this wonderful man. As everybody listening to this program and participating in this program knows, Stan Sporkin was the definition of an individual who was bigger than life. He was passionate. He had a huge personality. He had widespread interests. He cared about what was going on in this country, in government, in the financial community. He cared what this legal profession was doing. He cared about the judiciary. And in thinking about this, I thought, what words would, if I was asked to come up with a word to describe Stan Sporkin, what would that word be? Now, I first became acquainted with him when I was in law practice with my current firm, Gibson, Dunn & Crutcher in Los Angeles. And the corporate lawyers, the corporate transactional people were constantly gnashing their teeth about Stan Sporkin and his driving them nuts, driving their clients crazy and so forth. And then I met him when I came to Washington at the beginning of 1981 to be Assistant Attorney General for the Office of Legal Counsel. And I'll cycle back to that. But in thinking about what words we would come up with to describe him, I thought of a bunch of words, but one of them is maverick. Another is, to quote some of my partners at Gibson, Nunn and Crutcher at the time, a damn nuisance or a pain in the butt. And then many people felt of him as a conscience, an active conscience of our society and our culture and our government. Some thought of him as a scold. But the word that stuck with me is gadfly. And so I went back and I looked at the origin of that word, and I think most people know that in 399 BC, Socrates was tried by 400 or 500 citizens of Athens for his offenses against the state being the city-state of Athens, for impiety and corrupting the youth by teaching the youth about very seditious ideas and concepts and ways of thinking that Socrates advocated and put forth. And the trial of Socrates is written up by Plato, and it's one of the great documents of history. Socrates described himself as a gadfly. A gadfly, he thought of Athens as a giant, noble steed of great power and magnitude and force and authority. And a gadfly, of course, many people know, is this irritating fly insect that is constantly biting, flying around the horse, making the horse's life miserable, and prodding and irritating the horse. Socrates described himself as a gadfly. He felt that his role in Athens was similar to that gadfly, to be a pest, a nuisance, a scold, an irritant, to remind the people of Athens, the culture, the civilization, and the government, that it became apathetic, it became complacent, it became ignorant, and consciously ignorant of the values, the virtues, the ethics of the society. And it was his job, and he relished it, to be a gadfly, to remind the people of Athens and the government of Athens and the civilization of Athens where the government's and the people's weaknesses were, and to remind them of what their duties were to their fellow citizens and to their state with respect to ethics and things of that nature. That was how Socrates proudly described himself, and he almost won an acquittal from those 500 citizens. Not quite, but he almost did. But that is, in a sense, what Stan was to this country and to our citizens and our legal community and our legal institutions. He was a scold when he saw something that he did not like, that he thought was unethical, unfair, unreasonable. If he thought our society or our government or its institutions were forgetting their responsibilities to their citizens, to their institutions, to their oaths of office, then he would say something. And he wasn't too distracted or deterred by what the law limited his role in his particular capacities. And so I see this theme throughout his time at the SEC, when he was at the CIA, as a reminder of the rule of law and the responsibility of the institution to accord with the rule of law. And then when he became a judge, cases would come before him, and he was not deterred by the concern that he might someday be reversed by the Court of Appeals. And we'll see this over and over again, that he would take a chance. If he thought an injustice existed, he would point that out. He would enter rulings that were, maybe he knew he was going to be reversed, but he was going to draw attention to these things. When I first did meet Stan in 1981, when I came to Washington as a part of the Reagan administration, I remember a dinner party at my partner John Olson's house. He wanted me to meet Stan Sporkin in person and to get acquainted with him because he thought that we might be doing work together. And it turned out that was true, of course. But in the course of the dinner, I asked Judy Sporkin, I said, well, what's it like? Now, I mean, he was at the SEC and you know, his work, everything he did was in the public domain. Now he's at the CIA, it's all secret. What is it like when he comes home and he can't talk about anything that he did during the day at work? And she said, Ted, you have no idea how grateful I am for that change in his career. At OLC, the Office of Legal Counsel, I think everybody participating in this program knows it was the obligation and responsibility of the Office of Legal Counsel to render legal opinions to the executive branch, to agencies of the executive branch with respect to questions of law, whether something was legal, whether an agency was acting within its authority, when there were controversies between two agencies of government. And from time to time, Stan would show up in my office, often without any warning at all. And my assistant would say, Stan Sporkin from the CIA is here, and he's got a bunch of people with him. And of course, given who he was and my respect for him and the institution, they were ushered in immediately to my office. Stan would then sit down, and I'd bring a couple of lawyers from the Office of Legal Counsel in, and Stan would describe to me and I can't describe what he described to me, but they were potential activities, covert operations, things that the director or the head of the Bill Casey was thinking about, or other people in the agency were thinking about doing, but it was sufficiently on the edge that they wanted the blessing of the Department of Justice, Office of Legal Counsel. And then on this tale would be unfolded for me. And some of these stories were really way out there. And frequently I would, after consulting with my staff, or maybe sometimes without even having to do that, say, no, you can't do that. The CIA can't do that. So that's against the law. Stan never argued or complained. He would lay it out, and then he would accept that, and then he would go back to the agency, and he never told me. But I think that what happened when he got back to the agency is that he would tell the people, and it may have been Bill Casey, no, we can't do that. Not the answer that Stan wanted, because he knew that coming in. He's a very, very smart man. He knew that I was going to say, no, under the laws of the United States, that sort of thing can't be done. And he got the result that he wanted, but he was very careful to come in and check it out so that not only his opinion, but the Justice Department stood behind what he was going to do. I should talk a little bit about his role as a judge. I had only one case before him. It was a fascinating case involving a major advertising agency and two of its clients. And two of the clients had a conflict of interest, a conflict developed, and the agency had to turn loose one of its clients. That client sued the advertising agency, and the question was, can they do that? We were representing the advertising agency, and we wanted to case dismissed because it was a contract terminable at will. It seemed pretty obvious to us, but it was a fascinating case with great lawyers on representing the client that had been dismissed, and great lawyers representing the client that remained. And the arguments, we kept going before Stan over and over and over again, trying to get this case dismissed. He would ask these hard questions. He would lean back in his chair, as everybody knows, way back in his chair, to the point where I'll come back to that too. And then his eyes closed, and some people would think that he was asleep, but if you knew him, you knew he was never asleep. He was paying very close attention, because then he would ask very penetrating, hard questions. And in the jury box, there were half a dozen, or maybe sometimes 8 or 10 or 12 people, and I learned that those were interns. I don't know, I've never seen a federal judge with so many interns. I don't know how he did it, but he had a huge collection of interns, and the interns were sitting there learning what happens in federal court. And I kept saying to my colleagues, saying, why won't he dismiss this case? and someone said, Ted, that is a great, fun case. He's not going to let go of that case. This is an intellectual feast for him. He loves it. He likes the lawyers. He's teasing the lawyers. He's asking questions of the lawyers, and you're never going to get that case dismissed. And we finally wound up settling that case after certain issues came up with respect to recusal. Now, I became, and I remained very good friends over all this time during his jurisprudential years. And I was very close to Dick Hauser, who was a deputy counsel to the president. And Dick was friends of Stan Sporkin too. And I don't know how the tradition developed, but Dick Hauser and I developed a practice of every 2 or 3 months having lunch with Stan Sporkin and Stan Harris, the federal district judge Stan Harris that many, many people know or practiced before, a wonderful human being. And we called it the Two Stans lunch. And we would go someplace and talk, and no subject was off limits for Judge Sporkin, and we would talk about everything. At one point, because Judge Sporkin had leaned back so far in his chair during an argument in court, the chair, what happened, everybody thought was going to happen, finally did happen. The chair went over and Judge Sporkin was dumped on the floor. So Dick Hauser and I came up and presented him with, at one of these lunches, or it may have been at a judicial conference, with a helmet, a football helmet with the name Sporkin on it. And I can't remember whether we had a number. So this was for Stan in case he wanted to continue to lean back and possibly dump himself on the floor. And this would protect him from a concussion. Now, I don't know whether you want me to mention a couple of the more famous cases that he handled, and I can do that somewhat briefly, or we can cycle back. Mark, I don't know how you want to handle that.
Why don't you just give us 1 or 2 examples, and then we'll open the conversation among the panelists and address some of the questions that the participants have put on
Okay, I will do that. I will mention maybe 2 or 3. The one that everybody thinks about, or a lot of people think about when they think about Judge Sporkin, is the Lincoln Savings and Loan case, which was during that period of time when savings and loans associations were being operated in ways that resulted in failure, charges of fraud, mismanagement, all of those kind of things. And one of these cases was tried before Judge Sporkin, handled before Judge Sporkin, and he wrote a legal opinion, and I won't quote all of it, but he did he listened and he excoriated the management of this Savings and Loan Association. He called it looting. He said that that he was not going to turn the association back to the management that had looted the corporation. And he talked about how badly it had been mishandled, and how the leader of the association had said that he had and Judge Sporkin didn't believe this for a minute. The leader of the association, Mr. Keating, said he knew he was going to comply. He was complying with the law because he had surrounded himself with all of these professionals, accountants and lawyers and so forth. Judge Sporkin didn't buy it for a minute. He had listened to the evidence in the trial, and he was appalled by what had happened. And then he came up with the famous words that everybody, I think, remembers him for. Where were these professionals, a number of whom are now asserting their rights under the Fifth Amendment, when these clearly improper transactions were being consummated? Why didn't any of them speak up or disassociate himself from the transactions? Where also were the outside accountants and attorneys when these transactions were being effectuated? Those words rang out to the legal community, to the accounting profession, and have been quoted and remembered ever since then. What he was doing was saying, what were you doing, you lawyers and you accountants? So you think you can turn your eyes and blind to these kind of things? You have a responsibility. You have to do something. You have to disassociate yourself, or you have to come forward. And those words are forever identified with Judge Sporkin. The next one that I would mention is another famous case that he handled, the United States government brought an antitrust action against Microsoft. And the case went, it was the biggest antitrust case that the government had ever brought. It went on and on for a long period of time. Ultimately, the Justice Department, the Antitrust Division, entered into a settlement. And under federal statutes, that had to be presented to the district court. And the district court judge had an obligation to consider and approve or not the settlement. Judge Sporkin got very much into this. He was very displeased with the practices that the Justice Department had identified with respect to the conduct of Microsoft. He thought it was wrong. He said in his opinion that he'd read a book about Microsoft as well as articles in magazines. He was flabbergasted that the government wasn't doing more about it, and he refused to approve the settlement. That he sort of knew, I think, when he did that he was not going to be upheld. It went up to the Court of Appeals, and the Court of Appeals not only reversed him, saying that he went far beyond his responsibility and role as a district judge to tell the government how to prosecute an antitrust action, and he was removed from the case. It was kind of an unusual outcome from the Court of Appeals. But the point was, Judge Sporkin felt that this company was doing bad things. And he was not going to say, I'm going to put a rubber stamp that says my name, Stan Sporkin, federal district judge. I'm not going to do that. I'm going to point out what I think is wrong. And he did, and he took the consequences. And the last one I would mention was the Hugo Prince case. Hugo Prince was an individual who survived the concentration camp at Auschwitz. Members of his family were murdered. Other members of his family were killed as a result of the atrocities during the Second World War. And this individual brought a case against Germany for reparations, for damages, for what he had suffered. And the United States government and the lawyers on the other side representing Germany said, he can't bring this case. It's barred by the Foreign Sovereign Immunities Act. It went back and forth and back and forth. And Judge Sporkin was angry about the fact that this individual who'd suffered such atrocities in the concentration camps in Germany, and he couldn't bring an action against the country that he felt was responsible and should have taken responsibility for it. His language is very, very powerful. I don't have the time to quote it, but he was appalled by the fact that this individual could not bring an action against the country that had caused him so much damage. He refused, he allowed the case to go forward. He was reversed by the Court of Appeals, and I think, again, he knew he was going to be reversed by the Court of Appeals, but he was not going to stand by and let this terrible thing happen to Mr. Prince. When he had a chance, when it came back to his court, he allowed an amendment to the complaint to allow it to be brought against various corporations incorporated in Germany. Again, the Foreign Sovereign Immunities Act was going to be coming up. Ultimately, the case, as a result of the intervention of President Clinton and the State Department, and folks here on this call probably know more about this than I do, but a resolution settlement was made, and Mr. Prince received a monetary settlement. Again, it was something that was consistent with what I said at the beginning. This was an individual who looked out. He was a judge. He felt that it was his responsibility to do something about it. I'm not going to sit by and allow this to happen. This is not. And he said in connection with one of these cases, the question is whether a lawyer should become a slave to the law or the law should be an instrument of justice. There is a debate over which of these philosophies you follow, and the philosophy I have is followed by the losing side. In other words, I'm going to do what I think is right. I'm going to point out injustice. I'm going to do something about it. And then if the system changes the outcome, so be it. I will not stand by and let this sort of thing happen. If he saw an injustice, and it was the same thing over case after case in his career, he would point it out and he would say something, and all of us are beneficiaries of the fact that he exercised his conscience, his standards of ethics, and his willingness to be the gadfly, inflicting, biting, irritating prompts by the gadfly to the steed of state.
Thank you very much, Ted. That is quite marvelous. And I think you've hit on something that's of the essence, at least in terms of Judge Sporkin's management of his judicial responsibilities. He was a force for justice, and he was very controversial because he consciously took decisions that he knew were not consistent with the prevailing view of the law, let's put it that way. And the Prince case, I think, is worth saying another word about. I know Gene has some experience with that as well, but let me just say this. And I speak here as one of the authors, one of the drafters of the Foreign Sovereign Immunities Act, and also as someone whose wife was late wife was an officer of the Holocaust Memorial Council. And I have represented claimants who have benefited directly from Judge Sporkin's decision in the Prince case, because what happened was that the torrent of litigation against German and other foreign entities, corporations and state-owned enterprises and the like, was so troublesome to our foreign friends, our allies now, that they were willing, when Stuart Eisenstadt in the Clinton administration took this burden up to negotiate, took the opportunity of the pressure of this litigation to negotiate wide-ranging settlements with a number of countries, including Germany, Austria, many others, and some of those involved the repatriation of art, Swiss gold, and reparations arrangements that were, I mean, the German government, and I think the Austrian government as well, funded impartial claim settlement processes where claimants would have an opportunity to get restitution. So I was glad. I will make one other comment. The opinion reversing Judge Sporkin in that case, where he was on the right side of history, the wrong side of the statute, was written by RBG, Ruth Bader Ginsburg. But there was a dissent by another very significant jurist, a woman jurist, Pat Wald, who more or less went along with Stan's theory that this is such a fundamental violation of peremptory norms of international law that Congress could not have intended to bar litigation in U.S. courts. Of course, from the point of view of the United States, concerned about issues of international jurisdiction, universal jurisdiction, reciprocity, we had drafted a statute which was not aimed so much to redress the world's wrongs, but to try to find to demystify state enterprises and to permit litigation against state-owned enterprises in circumstances where there were sufficient nexus to the United States to authorize, in the view of the international community, litigation in a national court as opposed to an international tribunal.
Mark?
Do you have something else you want to say about Prince?
Well, I just want to comment on a couple of cases during my clerkship. One I think is very relevant to the events of the past few weeks. There was a case brought on behalf of a mentally disabled 14-year-old. He saw the police running after him, and because of his fright, he ran, and whatever happened, it resulted in him going to the hospital, medical records showing some severe injuries. And the issue was who is responsible. The Metropolitan Police blamed the Park Police blamed what other police organizations that govern the District of Columbia. They were all pointing the fingers at each other. They had one number of a long badge number of the officer responsible. So what did Stanley do? Thinking back to the foreign payments cases and the internal investigations, he says to the Corporation Counsel, representing the various police departments, I think I'm going to order you to conduct an internal investigation to find out the identity of this police officer. Well, the Corporation Counsel lawyer stood up and said, Your Honor, I don't think you have the authority to do that. And personally, I didn't think Stan did either. It didn't matter. Corporation Counsel went ahead, conducted the internal investigation, and they found out the identity of the responsible police officer. I also want to make a comment about Stanley the man. He and Judy lived a very modest life. Stan could have cashed in decades ago, made the biggest bucks. He did not. It wasn't until he got to Waugatcho that Judy seriously considered how to redo her living room and kitchen. He was the ultimate public servant. And he was also known for his frugality. Two memories of that. One, in the Textron case, John Olson had made arrangements for us to interview a couple of witnesses at the Gibson Dunn office in Paris. And Stanley, of course, wanted to know how much was it going to cost to get to Paris and back. In those days, we had Freddie Laker Airlines. We can go round trip to Europe for $250. That's the ticket that was purchased for those interviews. Also, his frugality almost disrupted my wedding. As my best man, he kept Brooke's wedding ring, well, the soon-to-be wedding ring, in his pocket. And he and Judy walked from the hotel to the wedding with Connie and Tony Morella. And he's always known to look for a bargain. So out on the street was a guy offering what appeared to be hot jewelry on the sidewalk. Great, gold bracelets, you name it, at bottom basin prices, and you can imagine why. Stan was very interested in that. A police car screeches to a halt, sees what's going on, and orders everyone to empty their pockets. This is the only time I know Stan disobeyed an order of a law enforcement officer. He kept the ring in his pocket, went on to the wedding, and the rest is history.
Well, thank you very much. We've had a few questions from participants, and at least 3 of them involve issues of the Long Distance Act in today's world, and particularly as it relates to the broader international community. In other words, one question is, what impact has the statute had on corruption around the world? Secondly, a person said that the statute is necessary. Is it sufficient? And someone commented on the importance of the OECD convention. I must say there's also nowadays a UN convention. I will make one brief comment on the situation. My knowledge, frankly, my personal knowledge is more back in the days when we were trying to establish these rules than it is in the current practice of the Justice Department and the international community. It fell to me in the Carter administration, after there was pushback from the business community after Congress enacted the bribery provisions of the Foreign Corrupt Practices Act, that the case was made with some intensity across the board in the international community, in the U.S. International business community, that we were imposing unfair burdens that, on U.S. trade and investment that were not imposed by anybody else. And I was asked by seniors in the State Department to try to persuade in the UN and in the OECD all other countries of the world to put the same restrictions on their companies so that they would be voluntarily give up, the scheme was, the competitive advantage that had accrued to them as a result of this legislation, or so the argument went. I spent 2 years trying to do that, and I won't bore you, but let me just, we did not succeed. In the end, in the North-South dialogue, the OECD, it was impossible. Why? Because those governments, a number of them, France, Germany, and England at the time, were financing the foreign bribes. It was part of their export promotion program. In the UN, the developing countries said, well, if you want to do something about foreign bribery, then you've got to give us our agenda, the demands we were making on transfer of wealth from the north to the south. And we just couldn't come to an agreement on that. But I think I would say that looking at Stan Sporkin's pride in this legislation is well-founded. I think it went too far in some respects, but in the fullness of time, we do now have some significant compliance among some of our competitors. From my perspective, it's very difficult to eradicate corruption in the world, just as it's difficult to eradicate poverty, as it's difficult to eradicate terrorism, as it's difficult to eradicate looting of antiquities. I worked on all those issues in a multilateral forum in the State Department. All you can do is try to keep pushing. If anybody else on the panel has an assessment on the impact on foreign countries, I mean, on the world, the issues of corruption.
There is very strong cooperation.
Indonesia or Russia or where have you.
There's very strong cooperation among the various prosecutors and regulators around the world when it comes to bribery. The Siemens case, for example, the Munich prosecutor actually took the lead in investigating $850 million in bribes in that case. And what would happen when it comes time for fines, whether it's in the Ericsson case last year or Petrobras, the recent case in Airbus, they divide up the fines and the disgorgement among the various countries. There's sharing of documents, there's sharing of basically compelling subjects of the host country, letting the US prosecutors and the SEC enforcement personnel to come over and interview foreign people. So if you look at the record and total up the tremendous sums of disgorgement and penalties, a lot of those cases represent joint efforts and they divide up the money accordingly. And that sends a message internally to those countries.
Thank you, Gene. That is very informative. Anyone else have a comment on this? Jim, Juliana, am I missing any questions? I've lost the track of the Q&A at the moment. I see there's 2 more that have come up here.
Yeah, we have 7 total questions, including some comments. I think you resumed them all.
These are very nice words about Stan Sporkin.
Yes.
And for that, we thank you. Now, did you say this is being recorded?
Yes, this is being recorded and we are hoping to put it on the website soon after it's ended. Yes.
Gene, there's several people who are visible to our participants, or at least 2 ladies who are visible to our participants, who under your name. You could introduce them?
No relation. I don't know who they are, and I don't know why
Right.
there's a glitch in the system listing them as.
I can explain. One of your partners, I didn't sign up soon enough. I was a friend of Judge Sporkin's, and I just wanted to concur with some of the things other people said. I do civil rights work, and I had a number of cases in front of Judge Sporkin, and became friends with him after he left the bench. And I also clerked for Judge Bryant, who, was a pioneer in terms of African-American lawyer, first chief judge.
Thank you very much.
Yeah.
Appreciate it.
And so Judge Bryant used to say about Judge Sporkin is he's the biggest mistake Reagan ever made in placing him on the bench. And then
Well,
Judge Sporkin had an unerring view of justice. And one of the cases he ruled, Judge Bryant had held unconstitutional a State Department policy that prohibited women from serving, married women from serving in certain parts of the State Department because they said they were not available for worldwide service. So Judge Bryant held it unconstitutional, was reversed by the DC Circuit. The same case, exactly the same case, comes before Judge Sporkin a few years later. Judge Sporkin holds it unconstitutional. And Judge Bryant had a conversation with Judge Sporkin and said, Stanley, I just got reversed. How could you do this? And he said, well, it's wrong and I don't care if I'm reversed. And as a result of his decision, the State Department changed the rule. And that was,
once again, he's on the right side of history. Thank you very much. Jim, did you have anything you wanted to add about Ron Contra?
Well, there was a lot of illegality there, but I think Stan kept the CIA. This is my opinion. Ted may know more about this than I do, but I think he kept the CIA on the right side of that. And there were several senior CIA officers that were charged with false statements, and they were eventually pardoned by President Reagan, along with Caspar Weinberger and some others. But Stan used to say to me, I cannot understand why they lied. Why did they do that? We were covered by the finding. Everything the CIA did thereafter that was legal. And why did they do it? I'm sorry?
This is not the place to debate the merits of that. I once had a public debate, brief one, with Leonard Garman about some of that back in the day. I can imagine the challenges that Judge Sporkin faced. William Casey was a powerful guy, and he wasn't always that sensitive to international law, at least. I was sitting in The Hague, representing arguing for the United States at the Gulf of Maine case when Nicaragua brought their complaint for bombing of their mining of their harbors and so on before the Royal Court. Those were tense days for any general counsel.
Well, I didn't mean to say that I thought that was legal. I was just referring to the arms transfers and the diversion of funds. But you're right. It's a very complicated scenario, and it would be a separate program in and of itself.
Ted, you want to have the last word?
Well, one of the questions that came to me at the Office of Legal Counsel, and I was reluctant to talk about it, but it did have to do with the mining of the harbors in Nicaragua and other things like that. I won't say what advice I gave, but I guess it happened anyway. The man was truly wonderful. He had this indefatigable sense of justice and fairness, and these lunches that Dick Hauser and I had with Judge Stan Harris, who was absolutely another wonderful human being and a wonderful member of the judiciary. These things, those conversations were completely free-flowing. Of course, he wouldn't have talked about a case that I was involved in or anything like that. So we didn't talk about that, but just about everything else was on the table. And he had this abiding curiosity about what was going on. Why were people motivated to do the things that they were doing? And it was over and over again, because I went, I said it was a thrill, not just to be able to talk about him, but to do the research and to cast back into my memory of my times with him. And we stayed very, very close. I represented Ronald Reagan in connection with the Iran-Contra investigation. And so some of that spilled over. I represented some individuals who brought claims under the Foreign Sovereign Immunities Act or around the Foreign Sovereign Immunities Act, victims of terrorism in various countries, and he played a role in dispensing some of the funds that were collected. So we stayed in touch all this time until just a couple of years ago. But he never lost his enthusiasm or his energy or his passion or his abiding sense of justice and fairness. And that cycled me back to Socrates talking about what his role was. And he almost won that case. And he almost won that case because he told the 500 jurors in Athens that you need me. I'm doing this for you. I'm doing this for Athens. You may find me to be a nuisance, a pest, an irritant, a prod, a scold, but I'm doing this because I'm pointing these things out. You want me. This society needs me. And when I'm gone, there won't be anybody like me. And in a sense, that brings me back to Stan Sporkin again. There's very, very people in the world like him. And I disagreed with a lot of the things that he did on the bench. I'm kind of a conservative as far as judicial restraint and things like that. That did not bother or impede Judge Sporkin. He was going to do what he thought was right, and he figured, well, the Court of Appeals, if they decide to reverse me, they're going to reverse me. But I'm going to put my stamp of fairness, justice, and decency on the people that come before me. I am going to be a judge. I'm not going to sit back and not do something about something that I think is wrong. And I think all of us that are listening to this program and all of us in society, and particularly in the legal profession, and of course the accounting profession too, but particularly in the legal profession, now I think all the time of it's not just our responsibility to be a zealous advocate for our client, but we have responsibilities greater than that. And that goes back to his words, where were the professions? Where were the professionals? Every student, I don't know, it's been a long time since I've been in law school. You guys are teaching, but I think students are taught those words, and they know those words came from Stan Sporkin.
That's a wonderful conclusion to a wonderful evening. Thank you very much, all of you.
Mark, if I could just add one last point. There is a continuing legacy at the SEC. It's called the Stanley Sporkin Award. It's given each year by the chairman of the SEC to the person who's made the greatest contribution to the enforcement division. Associate directors like Bill Baker and Rick Firestone and others feel great pride in having been recipients of that award. But that's something that continues every year and will continue to go on.
Mark, let me just clarify something that I said too. Stan, after the finding, he went onto the bench very soon after that. The CIA facilitated the arms transfers. The diversion of funds was clearly illegal. That was something that was really run out of the White House, as far as I'm aware.
Thank you. Juliana?
Thank you so much. Thank you to all. Thank you to the question and the participant attendees interaction with us. This has been recorded, so it was a wonderful evening. I thank you all. Bye.
Bye. Thank you.
Goodbye.
Thank you.